Hello, everyone. Thank you for being here with us today. Welcome to our first caring conversation for the new year. We're so happy to be here with you. The ARC of California is thrilled to offer Caring Futures, a proven resource program dedicated to supporting caregivers and family members of adults with disabilities. Understanding the unique challenges faced by family caregivers as they age, Caring Futures offers critical planning assistance, resources, and a supportive community. Caring Conversations is just one part of Caring Futures program here at the ARC of California. We will share more about our other offerings by Caring Futures at the end of today's conversation, so please stay tuned. If you need closed captioning today, you can access that by clicking the button in the bar below. At the end of today's conversation, there will be a question and answer session. At that time, we'll invite you to raise your hand or type your question in the Q&A to ask our guests directly. If you need Yes, just type your question in the Q&A directly. So if you haven't met me before in a previous caring conversation, my name is Felisa Strickland. I'm a sole parent caregiver for my daughter, Lily. Lily is 25 years old. She has a diagnosis of cerebral palsy, autism, epilepsy, and IDD, and she requires full-time care. We enjoy our challenging and fun life in Santa Barbara, California. Alongside full-time caregiver, I am a strong advocate for individuals with disabilities and their families. I serve as a board member for the ARC of California, as well as Alpha Resource Center of Santa Barbara. I also participate on many committees and enjoy getting involved in fundraisers and advocacy projects in our community. As a parent, a Caring Futures instructor, and parent educator, I am thrilled to be here for this important conversation with you and our special guest. Today's topic is planning ahead, public benefits, updates, and disability future planning. We are joined by Kevin Urbatsch for today's conversation. Kevin Urbatsch Esquire is the principal attorney of the Urbatsch Law Firm, PC, in Berkeley, California, where he specializes in special needs, estate, and settlement planning. He is a certified specialist in estate planning, trust, and probate law by the California State Bar and a fellow of the American College of Trust and Estate Counsel. Kevin also serves as the national director of the Academy of Special Needs Planners, leading over 500 professionals dedicated to enhancing the lives of individuals with disabilities. Kevin is nationally recognized. He is a nationally recognized author and educator in the field. He has written or co-authored leading texts including Special Needs Trust, Protecting Your Child's Financial Future, 10th edition, 2023, and Administering the California Special Needs Trust, 3rd edition, 2020. He is also the attorney editor of CEB's Special Needs Trust, Planning, Drafting, and Administration. A frequent speaker, he has presented at over 150 seminars nationwide, taught courses for judges and fiduciaries, and served as an expert witness internationally. A dedicated advocate, Kevin has been recognized as a top child advocate by Parenting Magazine and received the Presidential Recognition Award from the National Academy of Elder Law Attorneys. Through his writing, teaching, and leadership, including hosting the annual Special Needs Planning Symposium in Napa, he has played a key role in shaping public policy and advancing best practices in special needs and settlement planning law. Without further ado, please welcome Kevin.
Well, thank you so much. That was an awful lot.
Well,
Um,
that sounds like you've done an awful lot. So we're so happy to have you here with us today.
yeah,
Thank you so much for joining.
my pleasure. So today I thought I would kind of go through some of the fundamentals of planning for persons with disabilities. And generally, we would talk about what benefits there are to planning. And primarily, we're focused a lot on public benefits, how they can be used to address unmet needs, and what we mean by special needs planning. We'll dive a little bit into what kind of tools are available. We'll talk about special needs trust. We'll talk about ABLE accounts. We'll talk about some of the other options. And we'll talk about something that I think is critical for basically any parent of a loved one with special needs, and that's creating a memorandum of intent. So I thought I'd spend about a half hour or so going through just some of these high level concepts, and then we'd leave like around 30 minutes for questions. So,
Sounds good.
all right. So, generally, what do we mean by special needs planning? I know that I hear a lot from family members that they know they need to do something, that their loved one with special needs additional planning. But I always bring it back to kind of as a parent, you have a child with special needs, and I'm going to guess that you're the one primarily providing the care, advocacy, whatever they need, you're there for them. I do have a daughter with special needs as well. She has autism. She is high functioning. She is able to work, but she does need quite a bit of assistance. So we do spend a lot of our time, my wife and I, in managing her needs, her care. She has transitioned from age 18, so we'll talk about why that's a big deal for many of our children. But when we're talking about advanced planning, we really look at it in the sense of how do we replace that parent when you're no longer available. Either you could become incapacitated, it could be Alzheimer's, dementia, traumatic brain injury, or you die. Is your loved one with special needs protected? Do they have a plan in place, and is it a plan that will work? Because a lot of people will set up an estate plan, a will or a trust. They might even create a special needs trust, but I will tell you that having done hundreds of these, many of those special needs trusts, they end up not working, or they don't work as well as they'd hoped because they didn't think through some of the real challenges that the people you select to take control of that trust might have in taking on that responsibility. They just weren't ready for it. And so hopefully when we create a plan, we're thinking that how does this plan, not only does it benefit the planning, it benefits financial security, we maintain eligibility for public benefits, but we're also training those people who are going to take over for you when you're no longer able to do it, to step up and do the right, kind of services that you need. And so again, a big part of this is how do we find those people? And then again, just the basics of housing, advocacy, caregiving. And then we also want to make sure that everybody in the family has coordinated their plan. A lot of times people forget that grandparents or others might want to leave some money to that loved one with special needs, and if they don't do it correctly, it could end up causing issues. We can
Mhm.
usually solve those issues, but again, we're really looking at a problem. Is it's a more expensive solution. We don't want to spend money on people like me as attorneys. We want to spend money on the children. But if they leave money directly to a loved one with special needs, it does cause us to have to go to court usually to fix that issue. We don't want to do that if we can avoid it. And then we just want to preserve the money for the family. There are, again, options that if money is left directly to a person with special needs, we can still solve their issue, preserve public benefits. The downside, though, is when people receive money directly and they receive Medi-Cal, for example, on their death, we have to pay back Medi-Cal if you don't plan in advance. If you plan in advance, we can avoid that. So, one of the big issues that we have is we are concerned about money. I mean, again, we always want to make sure that there's enough cash available to that loved one with special needs to enhance their quality of life for their whole life. And what that means is, because the definition of disability for public benefit programs means a person has a physical or mental impairment, but that physical or mental impairment prevents them from basically getting a job and earning a living. So we kind of look at it a little bit like, well, this person, we're creating basically a retirement plan for an 18-year-old. And how do we have enough money to make sure that that person with a disability has enough money to last them throughout their entire life? And that's where public benefits come in. We want to make sure that whatever money you can leave them is supplemented by what the government will provide.
Mhm.
And so there are certain different benefits. I've highlighted the kind of most important ones for people with disabilities on this slide here. And The big one generally we look at first is supplemental security income, or SSI, and it's run by the Social Security Administration. It's a federal program, so it should be the same in all 50 states. The rules are the same. Um, the issue with SSI is it's what we call a needs-based benefit. What that means is you could qualify as a person with a disability under the definition that the federal government has given us, but if you're not poor, they're not going to give you this benefit. And they define poor as you must have less than $2,000 in your name to qualify for SSI. So when we say needs-based benefit, that's what we mean. So when we look at this, understand that I have families come in to talk to me and they kind of say, well, my child's severely disabled. She can't work. Why does she not have SSI? Well, up until age 18, they look to mom and dad's income and resources to see if they qualify under that poor test. Or do you have too much money or do you have too much income? At age 18, they look just to your child. And that's where the critical distinction is. At age 18, they could qualify for SSI. Now, when mom and dad, when we're doing planning, we have to go, well, if mom and dad want to leave money to that loved one, how do we do it in a way that it won't be counted against them for that $2,000 resource test? And the way to do that generally is a special needs trust. Okay, so that's why special needs planning is so essential, because if you don't do that and you leave money to them in their name, then that would be a countable resource and would knock them off that SSI. Now, SSI is kind of the foundational program that opens up some of these other benefits. So, for example, you qualify for at least $1 of SSI, you automatically get Medi-Cal in California. And that's true in most states, but not every state. So also understand that a lot of these benefits that we have in California are not available in other states. And we're actually one of the better states with programs. Um, you can look at a map of the Civil War and see who provides better benefits. Usually the northern states, the southern states generally provide not as good benefits. So with SSI, you qualify for Medi-Cal. Now, Medi-Cal is the healthcare payer. It can be free, or sometimes if that person has a little too much income in their name, that income can knock them off into something we call share of cost Medi-Cal, meaning you have to pay a certain amount of your income each month before Medi-Cal will cover your bills. If you qualify for Medi-Cal, you can also open up eligibility for in-home supportive services, or IHSS. And that's basically if you need assistance residing in the community, then you can qualify for a caregiver, and the state will pay for that caregiver up to the maximum number is 283 hours a month. So the community, the county will come in, do an assessment, determine how much care is needed for this person to remain in the community. Now, if you do your math, you're going to find out that 283 hours a month does not cover 24/7. But it is what's available. And quite frankly, in California, our IHSS program is much better than what's available in other states. You get put on waiting lists, and sometimes you don't ever get your in-home caregiving. So if you qualify here and you qualify for the hours, you do get that benefit. All of those benefits are needs-based. Now, as I mentioned, SSI has a $2,000 resource test. You qualify for that, you get a monthly check. The maximum check this year would be $1,233.94, $1,233 in 2026. And that does have a cost of living adjustment each year. It doesn't sound like a ton, but it certainly is very helpful. And again, it's a pretty good benefit over a lifetime with that cost of living adjustment.
Mhm.
You automatically get SSI, you get Medi-Cal. Now, some people don't qualify for SSI because perhaps they have income from another source. Maybe they worked for a while and they have a stream of income, or somebody's left them an asset and they have income. If that happens, they would not automatically qualify for Medi-Cal. But Medi-Cal has other doors for eligibility. You can independently qualify for Medi-Cal. And so there's generally traditional Medi-Cal or Magi Medi-Cal. Magi Medi-Cal is a type of Medi-Cal, they don't look at assets, they just look at your income. But it's only available for people between 18 and 65. And this is the Medi-Cal that the federal government right now is trying to cut. It's based on Obamacare. And so it's possible that Magi Medi-Cal is going to be more challenging to get into the future, but currently it is available. No asset test, you just have to be low income. Traditionally, people with disabilities qualify for traditional Medi-Cal, and that's because of their disability, they can qualify, but their assets have to be under $130,000. So again, the asset test is bigger, and that's something that changed. You might have heard that Medi-Cal eliminated its asset test, and that was true from 2024 and 2025. Unfortunately, where are we? The 22nd, 21 days ago, they reinstated the asset test for Medi-Cal. So it's 130,000. Okay. So that's why that column is needs-based benefits. There's entitlement benefits that if somebody has worked and paid into the system that and then they become disabled, they can qualify for Social Security disability insurance or SSDI. They don't care how much money is in your bank account. They don't care what your assets are. They only care that you meet the definition of disability. Again, a physical or mental impairment that prevents them from working, or what they call substantial gainful activity, which they define as being able to go out, get a job, and earn about 1,690 bucks a month. Okay. Now, the government did us no favors. They qualified one SSI and the other one SSDI. They're both administered by the Social Security Administration. And so we have a problem because they're completely different eligibility programs. SSI requires that the person be poor to qualify. SSDI, it doesn't matter, but you've had to pay it into the system as an individual to qualify for SSDI. Okay. Now, childhood disabled beneficiary benefits, or CDB, you also might hear it referred to as disabled adult child or DAC benefits. What this program is, it's kind of a subset of SSDI. And basically, if your child was disabled before age 22 and they were never able to work and do that substantial gainful activity, meaning they couldn't go out, they lacked the ability to go out, get a job, and earn up to $1,690 a month this year. They were never married. They can qualify for on your work record. So if you paid into the system yourself and then you became disabled or you retired, they qualify for 50% of your check. And that doesn't take the money away from you. It's just in addition. Okay. We like this benefit because usually it pays more than the SSI check. Plus, there's no asset test. So it's easier to manage. And what I like to tell my clients is we can't screw it up, with the how, because there's ways to screw up SSI and Medi-Cal and IHSS by poorly administering, say, a special needs trust, or as a parent, if you're giving cash directly to your child, that could be counted as something called unearned income and could cause a problem. Okay. So we want to avoid that. With CDB benefits and SSDI, it doesn't matter. You can't screw them up as a parent. You can't screw them up as a trustee of a special needs trust. And then the other thing with CDB or DAC benefits, after you die as the person who paid into the system, they can qualify for 75% of your check. So again, it's usually a lot bigger check than what SSI provides. The additional benefit of those benefits is if that child stays eligible for SSDI or CDB benefits for up to 2 years, they can then qualify for Medicare. And we like Medicare too because usually there's more physicians, more hospitals, more care for that. And so a lot of my clients, we want to get them on Medicare and Medi-Cal, or what we call Medi-Medi, or dual eligible. And if they're dual eligible, Medi-Cal pays for certain things that Medicare doesn't. One is the IHSS program. Medicare doesn't have an in-home caregiving component. So caregiving is really only available through the IHSS program. So I'm kind of going into this detail because This is the kind of pre-planning that we'd like to see with our clients to make sure they understand what's going to be available from the government. Um, and we want to make sure, again, we're trying to pull as many resources as we can from as many different sources as we can, because money's always going to be an issue going forward. There are, of course, other benefit programs. A regional center, if the person is developmentally disabled, they can qualify for regional center. This is a California only program, and it is birth to death benefit. And again, they don't care about your money. Well, let me rephrase. They're supposed to not care about your money. Every once in a while, we have to fight them on, remind them that they don't have to care about your money or the money of the person. And there are some components where I think the parents have to pay a little bit, but generally, if a special needs trust or other assets, they shouldn't care. And again, regional center can be a wonderful benefit for many of our clients. Occasionally, you run into issues where you could qualify for payment for a regional center benefit. I know more of our rural people have trouble finding care providers, and that can be a challenge. But again, understand that regional center does provide some excellent care and can do great advocacy. For example, our local regional center was able to get my daughter on Section 8 housing, which is the next benefit, which is a real challenge in California, frankly, nationwide, because you can qualify for federal housing program under Section 8. It's the Housing Choice Voucher Program, which would allow the federal government to help you pay your rent. And what all you have to pay is 30% of your countable income. And if your only income is, say, SSI, you're looking at $300 or $400 a month in rent, and then the federal government will pay the balance to the landlord. And over a lifetime, you can imagine, of course, California being what it is as far as rent goes, this is a very valuable benefit.
Mhm.
The problem with Section 8, unlike SSI, unlike Medi-Cal, unlike Regional Center, you could qualify for Section 8, but it doesn't mean you get it. You have to be either put on a waiting list, or, which is more common you're seeing in California, is you have to wait till the waiting list is open before you can join it. And then sometimes it takes years, decades to get it. But if you get advocacy, especially for people with disabilities, they need to provide reasonable accommodation for them. You can sometimes jump the list or get added to the list, or sometimes other benefits. So with proper advocacy, and again, regional centers are a good resource here, depending on your local regional center, in finding proper advocates.
Thank you for sharing that, Kevin, because that's a really important point. I get a lot of questions about the Section 8 housing and how to navigate that because the list is so long. So thank you for adding that point. Very
Sure.
helpful.
I see a couple. Let me ask, I can answer some of these questions quickly. CDB is considered a part of SSDI. And again, it is Social Security Administration. They do use CDB, although I see them say CDB or DAC. Um, they tried a few years ago to say DAC. I'm sorry, CDB, but I still hear it referred to as DAC more often. Um, the federal portion of the SSI check, $996 is the federal portion this year, and then the balance is California's portion. Um, the age of disability, you just have to be disabled before age 22 to qualify. And with CDB, mean 50% of, yeah, it's one parent social security check, and they pick the higher wage earner parent. So whoever has the higher wage, I mean, shocking. The government actually gave us a benefit on that one. Yeah, the higher wage earning parent would qualify. Um, and again, it does, and you qualify for CDB or DAC benefits, it does take 2 years to qualify for Medicare, just like SSDI. They're the same program. CDB is a subset of SSDI, but I break it out here because this is really a program for people who have children with disabilities. Um, and then a benefit also in California is if they qualify for SSI, they can also qualify for CalFresh or the SNAP benefit, which is the food benefit. For many years in California, they wouldn't let you qualify for both, but I think it was 2018 or 2019 they finally opened it up, and so now you can qualify for both. And again, it's a nice little $289 a month for food. Again, we're always looking for every nickel we can. Veteran benefits are a complete subset. So if a parent or the person with a disability is a veteran, there might be additional services that they can qualify for. Okay. So again, I can do like 2 hours on SSI alone. I could do 2 hours on any of these programs alone. So there's a lot of detail built into these programs. But I'm going to jump real quick into this because if you're not aware, and hopefully you are, um, you can now get Social Security information by creating your own My Social Security account. And this
This
is
is a lifesaver.
super valuable. Oh
Yeah,
my
a
God.
lifesaver. Yeah, love it.
Yeah, I
Made
used
it so
to.
much easier for me managing my daughter's stuff. Yeah.
It's crazy. And when we had clients come in, a lot of times, again, because remember, we have SSI and SSDI. And frankly, the people who were receiving it didn't know. They didn't know which one they had.
Yeah.
It completely changes how we do a plan. I mean, because if somebody needs needs-based benefit versus, say, SSDI, it might change what we do. So they'd come into my office, we'd call the SSA way back in the olden days, and we'd sit and wait on hold. And usually we'd have our whole meeting, and usually 1 or 2 hours later, they'd get on and we'd figure out which benefit they had. Now you can just do this, and they'll send a benefits verification letter, like same time. It's really nice. Okay, so just make sure you do it for yourself and make sure your child has their own account.
Yeah, you can do it like, for example, in my situation, I'm my daughter's appointed representative. So
Yeah.
I have my account and then I have another tab for hers. So they're all on one login. But yeah, that's been amazing to just be able to do that.
Okay. Um, so again, when we're creating a special needs plan for a loved one with special needs, there's really two components. We're looking at, financially, that's what I've been talking about a lot, but there's also of the person. And what we mean by that is who's going to make because the other thing to remember, when your child turns 18, they could be profoundly disabled, unable to communicate, nonverbal, but under the law, they're now an adult, and you, as the parent, lose the ability to make their decisions. And the only way to regain that legally is either through a conservatorship of the person, or if they do have capacity, you could have your loved one execute something called a durable power of attorney or an advanced healthcare directive. So at age 18, if you want to retain the legal authority to make decisions, you should look, and then there's also a supported decision making arrangement too. But any one of these options should be explored. Now, I'm sure there's people on the call saying, well, my child's 28 and I've never had this and I've never had an issue and my child doesn't have capacity. That's going to happen because you're going to find the reality is that most everyone will still look to you to make decisions for your loved one with special needs. The problem is that legally you don't have that right. So if they challenge you, there's nothing you can do as, say, a parent to, you know, again, we get this sometimes with IEPs, and they kick the parent out of the room. Or it could be doctors refusing to share information, medical information with you of your child because of HIPAA laws. So we have to be, again, I'm not insisting that you go out and rush out and get that conservatorship or whatever right away because you may not need it, but just understand that you do not have the legal right to make their decision anymore. And so if they do have sufficient capacity to contract, um, I generally recommend as part of the plan that they complete a power of attorney and an advanced healthcare directive saying, if I don't have capacity, I want my parents to make my decisions or whoever, and then put backups in place. This would prevent the cost of having to go in and get a conservatorship, which is a procedure in California where you file paperwork with the county and the local probate court. Um, it is extremely difficult to get a conservatorship in California because, thank you, Britney Spears, she created this whole issue now. And so even people who need a conservatorship now are finding it difficult to get one because, again, now there's a court-appointed attorney. There's a investigator who comes out, does a full investigation. The regional center will issue a report, And you do all of this and then you go to court. And again, it's a big deal. You're taking away somebody's civil rights. So it's important that we follow the steps. But without the piece of paper, what we call letters of conservatorship, you don't have the legal right to make decisions after age 18. So again, part of the special needs plan is to make sure after you're gone, and again, that kind of practical reality where people will talk to the parents sometimes doesn't translate to, say, a sibling or somebody else, beyond you as the parent. Plus, if they don't like your decision, whatever it is, they may challenge your legal authority. So that's where the conservatorship kind of comes in and takes over. So that's what I look at here as far as the gold standard map here. This is kind of everything we're looking at. We want to make sure that the parents have created their own third party special needs trust for their loved one. They've created their own revocable living trust. It's important to get a lifetime care and benefit analysis. You want a financial analysis, like how much is it going to cost to care for my loved one for the rest of their life? There are financial advisors who specialize in doing that. Um, Part of my Academy of Special Needs Planners group is both attorneys and financial advisors, well versed in people with disabilities and their needs, their costs, and how that does, and how that would work over a lifetime. A care and benefit analysis, there's a group I use a lot called National Care Advisors, Ann Kerner's group. She has a nationwide network of basically registered nurses who specialize in this area, and they can get down into the nitty gritty of how much does it cost to care for your loved one. And then your memorandum of intent is basically, how do we download all your information? How do we get that on a piece of paper so that you're in, because basically no one's going to know your loved one like you do. No one. And how do we get some of that information down so that the people who take over after you're gone kind of have the benefit of your experience? And that's what a memo of intent or memorandum of intent, you might hear it referred to as a letter of intent, any of these phrases, it's all the same thing. ABLE accounts, which is kind of stands for Achieving a Better Life Experience. And it is a fabulous account. It has some benefits because the person with a disability, if they have capacity, can actually manage that themselves. Unlike a special needs trust, which they cannot manage. And if they have capacity, it's kind of a burden on them to have to do that. And then with the special needs trust, if that loved one with special needs has some capabilities of managing some of their money, even though they can't manage the special needs trust, we can give them something called a TrueLink card, which is a prepaid Visa card that they can go out and use, like, and buy things. Okay, so is flexibility here. So some people think, oh, the third party SNT, it can't pay for stuff, it can't do this, it can't. That is not true. It is as broadly, you can use it for anything that enhances the quality of life of a loved one with special needs. So again, how do we replace the parent? Well, we have to get a legal team, tax team, care management team, a trust protector, because we want to make sure whoever's in charge of that trust is doing the right thing. We need a trustee. I generally recommend a professional, and we put the family member on as a trust advisory committee. So this might be the siblings, and then a financial advisor. And so I always talk about the ideal trustee. They have to know all the laws on how to manage a trust, all the laws on public benefits. They have to understand that the money is in that trust is not theirs. It's for the person with a disability, so no self-dealing. They have to really understand how to properly invest the money, make tax efficient decisions, keep impeccable books and records. It's good for them to have insurance because if they mess up, they're going to be legally responsible, and they could privately have to lose their own money if they make a negligent mistake. So it's good that they have insurance or they have deep pockets. They know how to identify and fix bad service or second rate service. Again, people with disabilities are generally abuse. There's undue influence, all kinds of things that can happen. You have to be able to understand that. You have to understand real estate if they're gonna rent or buy. We have to understand how that works for a person with a disability. They have to understand care management, caregivers. There's tax issues with that. Generally, They have to be employees, not independent contractors, which means workers' comp, all the tax withholdings, and all the other responsibilities. The other big concern with caregivers, are they reliable, safe? Can you do background checks? And then as a trustee, they have to also be a good communicator, but they occasionally have to say no. They have to be able to say no sometimes because, again, they're the ones responsible for managing this trust, this money for the loved one with special needs over their whole life. And then it'd be really good if they were psychic, immortal, and omniscient. So if they had all of these things, that's the ideal trustee.
Oh, goodness.
So a lot of times people come into my office and they say, well, I think my sibling could be the child sibling could be the trustee. Generally, and a lot of times the sibling's surprised when they become the trustee because they were never consulted.
Mm.
And they might have their own life, their own family. They might not live nearby. They may not have, maybe they want to support their sibling with special needs, but they just don't feel like they're capable. This is where I generally recommend having a professional be the trustee, like a California licensed private professional fiduciary, who are individuals licensed by the state, who specialize in being trustees of special needs trusts or conservators of people with disabilities, and let the sibling supervise them. And if they don't like the way they're doing their job, we give them the right to remove and replace them, fire them if they don't like it. It's a check and balance, right? And so the benefit is the sibling is involved, the family's involved, but they're not responsible for writing the checks, doing the taxes, making the investments. And if they screw up, usually a private professional fiduciary has insurance and they can refund that money to the trust. And again, the sibling then is still a sibling. Because the other thing about siblings, especially if the beneficiary has capacity, is there's some resentment. Like I have to ask my sibling whether I can, go to the movies. I need money for that. So it can cause problems. And so this is why I like having a private professional when it's appropriate, with siblings as a trust advisory committee or part of a committee. And the other benefit of a committee is that they can remove and replace a trustee, and they can remove and add people to the committee as people drop off. So that, again, this special needs trust, we hope, will last for many, many decades. And so anyone you name in there, you want to make sure there's a very good system for replacing them over a lifetime. Okay. I mentioned quickly ABLE accounts. So an ABLE account is an account. Remember I said there's a $2,000 asset test for SSI, a $130,000 asset test for Medi-Cal. You put money into an ABLE account, it doesn't count against that asset test. Just like a special needs trust is also exempt, an ABLE account is exempt. Now, beginning this year, to use an ABLE account, you have to have been disabled before age 46. Before this year, it used to be 26. Now it's 46, so it opens it up. You can open the account at any age. You can use, every state has an ABLE just about, but in California, you want to use CalABLE because there's a benefit here for that. You can only have one account. This year, you can fund it up to 20,000. And if the person works, they can actually add in their own wages up to 15,960 this year. Everything inside the account grows income tax free. As long as it's used for qualified disability expenses, it comes out tax free. QDEs are very broadly defined. The IRS has been very generous. Unlike Social Security, I don't know why, but IRS is actually our friend in this world. Very broadly defined. Basically, you can make a distribution for anything that enhances their quality of life, and they consider it a QDE. I think we said maybe paying illegal gambling debts. Maybe that's not one. I don't know. We couldn't even think of one that's not a QDE. But if they do have a non-qualified expense, it does, then the distribution is penalized with income tax and a 10% penalty. So you just don't want to do that. But again, I've never seen one. As long as the account can grow up to 100,000 before SSI is, that's the asset test for the ABLE account. So up to 100,000, they continue to get their SSI. So the asset test for that individual would be 102,000, 100,000 in ABLE plus 2,000. If the person doesn't qualify for SSI because they have income, then the assets in ABLE can grow up to 529,000 before it interferes with Medi-Cal. So it's 529 plus 130. So you can see there's quite a bit of money there that they can have. You can move your ABLE to different states if you want to, but again, I would recommend keeping it in California. If they have an existing 529 plan, because a lot of families set up 529s when the kids are young, but maybe they don't realize that their child has a disability that will prevent them from working, you can start shifting money at 20,000 a year from that 529 to ABLE, so that they can use it for these qualified disability expenses. Now, traditionally, the ABLE account requires on the death of the person a payback to Medi-Cal for Medi-Cal, whatever assistance they receive throughout their lifetime. But if you use CalAble, California said they won't go after that. So you can leave that to family. Okay. So that's a big benefit. And this basically is the website. It takes about 15 minutes to join a CalAble program, and that's where I would recommend. And I know I'm jumping a little late, but I did answer some questions. So finally, um, I mentioned before the memorandum of intent. This to me is my favorite document. This is the one. Look, I love my special needs trusts. I like to draft them in my powers of attorney and advanced healthcare directives, but they're legally drafted documents. When we look at it, actual administration of a plan, the memo of intent is what people look at the most. The trustee, they want to see what mom and dad wanted, right? They want to see what the parents want for their loved one with special needs. And again, it's really critical that you get that information down. You can guide them like, here's how I envision my loved one. I want them living independently with the supports as needed. I don't think they can live independently. We would like them to be in these facilities, board and care. We like this board and care. Um, we like these family members. We want them to be around. We want them to support them. Here's some family members we don't want them ever to be around. You know, these are the kinds of things we need to know. And it's really important. Now, I've been preaching memos of intent for 30 years, and for a long time, my clients would tell me how important it was to do it, but they would never do it because I will tell you, it is hard. I mean, when I had to do this for my own daughter, it was much more challenging than I thought. So my wife and I created a workshop, and it's free. So if you use the QR code, you can get access to a 1 hour workshop. It talks about what kinds of things you can use or put into a memo of intent. Alongside that, there are some basically 2 or 3 different PDFs, fillable PDFs to get you started. And then usually what I strongly recommend is that maybe on your loved one's birthday, you pull it out and update it because things change. And again, we don't want a memo of intent that was done in 2000 when like right now we're in, God help us, 2026.
I love that. I love that you're talking about this too, Kevin, because this is such an important part of our future planning classes that we offer with Caring Futures. We
Yeah.
call it a planning guide,
Okay.
and it talks about all the things that we've been talking about today. But one of the most important parts about it is being able to identify you and your loved one that you're caring for, being able to identify the things that are important to them,
Mhm.
how you want to put those into place, what questions to ask to get you started. So I think that your tool alongside our tool is going to be a wonderful resource for families to get that started because that is exactly right. You need to have all the legal stuff taken care of and in place, but the one of the most important parts to us as parents is making sure that that quality of life is maintained, that the care that we offer is, at least as close to that same level as it can get. And another part of that is the circle of support, like making sure that you're having good conversations with the people that you're going to leave that responsibility to, and kind of giving them this guide so that they can, take over and feel confident that they've got the information that they need to. So I'm really excited about that. I'm gonna use that QR code right now myself.
And then you did mention that I had written a few books. I have a new book coming out. Actually, it'll probably be available next week. I just submitted it to Amazon for publication and it should be ready next week. So again, this guide is called Administering the California Special Needs Trust, but it actually is just as useful for a parent because basically a special needs trust is like a third party paying for services for a loved one with special needs. And as a parent, especially for somebody on SSI, Medi-Cal, IHSS, you as a parent, and if they're adults, you have to make sure you make payments correctly. Otherwise, you could end up jeopardizing their benefits. And sometimes I have parents come to me, they're like, oh, I've been supplementing my um, loved one's care all along, um, and there's no issue. And I'm like, well, that's just because they haven't caught you yet. They're going to find out eventually if you've been, say, supplementing, giving your loved one an extra, say, $500 a month. So what that would do for SSI is it would reduce their SSI check by $480 a month because they let you give them $20 for free because they're so generous. Anything after that is a dollar for dollar reduction off their SSI check. They may not find out for 10 years that you've been doing this, but they may find out. And usually they find out because somebody tells them innocently, like, oh, how are you able to live, where you live off SSI? And they're like, oh, well, my mom gives me an extra $500 a month. Oh, thank you for letting us know. How long's that been going on? Oh, for 10 years. Then you're going to get a letter in the mail the next day. You owe us 10 years of SSI checks. They call that an overpayment. And so again, and then going forward, they'd reduce the SSI check. The book here kind of talks about how to do that without interfering with their eligibility and how to manage that. So again, I'd encourage you, if you're interested, this is a really solid guide. It's written for consumers. It's in question and answer format. I started this 25 years ago, and I thought I'd give my clients like a little handout on how to administer these trusts. And as the questions kept coming in, it started as like a 10-page handout, and now this book is, close to 800 pages long. So there's a
Wow.
lot to it. And then there's one other book. A lot of times families come to me and they're like, they find out what my fees are. I do charge for setting up special needs trust. But again, our fees are what they are, but a lot of the families I know are struggling. And so we did help do a self-help book, and it's through Nolo Press, and you can create a third-party SNT. So there is a form in there that you can use as a parent to set up your own trust. So again, I just wanted everyone to know that that is available. So we do have time for questions. Let me kind of skim through these.
Well, if you're okay, we can go over a little bit if you're okay with time. I don't want to
Oh
keep you
yeah,
longer, but
I'm
yeah,
fine.
but I'm fine with that. I have a little bit of extra time too. So I want to dive into everyone's questions, and I really want to thank you for giving us the detail that you did, Kevin, and offering those resources, especially to families that may not, be able to hire a firm like yours, but still have some of these challenges that they want to take care of. So great resources, and we'll share those also in our thank you letter to everyone too, so you'll get more information there. So let's go ahead and dive into questions.
Well, I'm looking at the question. Yes, somebody was informed the ABLE account, if it exceeded 240,000-ish, the probate is required. It is counted. Yeah. So what you're looking at is what we call the small estate in California. If you have under that, then you don't have to do a probate. You can just do a declaration. It's true with an ABLE account, and they also don't let you currently name a successor beneficiary unless they have a disabled sibling. So it is a bit of a challenge, after death. Again, I don't know. So far, I haven't seen this become too big of an issue. But again, understand that the remainder beneficiaries will be the probate estate. So if your loved one can create a will and they want to leave it to somebody, it's a good idea to create a will and say, I want it to go to these people. Otherwise, it just goes to their then closest living relatives, usually parents, whatever. Um, People are asking about the funding of these public benefit programs. So if some of you have probably heard about the big, beautiful billionaires bill that is aiding all of the billionaires and making more money, they did it at the expense of a lot of these programs. So
Mm,
they're taking about $1 trillion away from public benefit programs. And now understand that most of these um, attacks won't be implemented for 2 to 3 to 5 years. So I'm hopeful personally that, we'll have midterms and other elections and it may unwind some of this. But
Mhm.
currently, what they're mostly attacking is that Magi Medi-Cal. And again, that does not impact people with disabilities too much because they can qualify for Medi-Cal under a different program. But that doesn't mean that these huge cuts won't cut services. So I'm going to guess if these things go through and they get implemented in 2027, 2030, when they're supposed to, that it will not, it will have a very big effect on what services are available in California. Again, it's too early to tell at this day today what that's going to look like. In about 2 or 3 months, we're supposed to see regulations come out how states are going to implement these cuts. I have a program in February where I'm bringing in a state expert and national expert on what's going to happen to these public benefit programs. But even they, at this point, it's a little early for them to even know. They have some ideas on what this looks like, but no one really knows at this point. My only suggestion is go to the ballot box. Vote for people who support, you know,
Mhm.
support our programs, support people with disabilities. Again, right now, that's what I think is most critical. Um, so again, it's a little hard to say right now what that's going to be like going forward, but it will have an impact. Right now, SSI has not been impacted. It's really focused mostly, in my opinion, on the Magi Medi-Cal. Um, But as I said, it looks like Medi-Cal services will be reduced and it could impact IHSS at some point too. Let's see. You can have both a trust advisory committee and a trust advisor. Generally, basically, these are just people in your special needs trust that you're giving different jobs to. One might just be there to supervise the trustee. One might be there to assist in making decisions on who makes distributions or what they should be for. So again, you as the person who's setting up the trust can set out whatever rules you want to do that. Wow, you guys are coming fast and furious on the questions. um, if one parent retires and one is working, is the 50% based on the retiree? Yes, it's on the retiree. And if the other parent then retires and has a higher wage, then they switch over to that parent's work record. I think max SSI in California. My best guess it's 1233, $1,233.94. It may be a little different, but we'll see. But that's around where it will be. Yeah, it is true that with again a lot of these public benefit programs, it's the exceptions that are that drive you crazy. The general rule is it's 30% for Section 8 housing of that person's income, although it could possibly be as high as 40% depending on your situation. But generally, it's 30%. If your child's on CDB and has IHSS, do you still have to be concerned about income limits? Yes, you have to stay
Yeah,
qualified for Medi-Cal. Okay. If you
I'm
don't
gonna
get
say yes.
Medi-Cal, you don't get IHSS. Yeah, so you do definitely have to be aware of that. Veteran benefits, I'd love to go into more detail, but again, it's just there's tons of programs. If you Google California veteran benefits, there's a lot there. I guess one thing I will say is if you have a military pension and you can name a special needs trust as the beneficiary of your military pension. That's something that wasn't true a few years back, but
Oh, wow.
it passed a law on it. But it has to go into what we call a first party special needs trust, and you have to follow some very strict rules. So again, if you are a military person and you have a military pension, we can leave it into a third party trust, and that's good news because it won't interfere with their benefits. How does receiving child support impact needs-based benefits? It is bad. It will impact their eligibility. It's accountable income when it comes in, and if it's held in the name by the next calendar month, it's counted as a resource. But if you irrevocably assign child support to a special needs trust, it won't count against them. Okay. And California law allows that. They have a special law that says you can do that. For those on SSDI, please confirm that they can receive both Medicare, yes, and Medi-Cal, yes. Yeah, you can qualify for both as long as you. So what happens if you're on SSI and you have Medi-Cal, and then you then qualify for CDB or DAC benefits, and you get more money, that's counted as unearned income for SSI. So you could lose the SSI. But because your Medi-Cal is tied to your SSI, does that mean you immediately lose Medi-Cal? The answer is no. What Medi-Cal has to do is they send a letter, a redetermination letter, to see if you otherwise qualify for Medi-Cal, and then they check, does the person have more than 130,000 of assets? No. And then there's an income test for that. Generally, the person can qualify. What you don't want to do is ignore that letter. You ignore the letter, you lose your Medi-Cal. But generally, if you get the higher benefit, just know that you'll keep your Medi-Cal until they do a redetermination. You should stay qualified. Do you have to notify SSI of having an ABLE account? That's a great question. I mean, I could argue no, because again, you only have to notify the Social Security Administration of a change in income or resources. An ABLE account technically isn't that, but I would notify them. I would just let them know. Um, any guidance on how to name or not name the ABLE account if you have an SNT? Well, you're not really. The ABLE account is exempt, so it would just be the name of the person who is disabled owns the ABLE account. Even if someone else controls it, it's still the money of the person with a disability. It wouldn't be in your estate plan. In their estate plan, I think you would just say, on my death, any assets I own as the individual with a disability shall go to A, B, or C, right? You don't need to name the ABLE like that. Let's see. Oh boy. So there are, yeah. Have I encountered errors in SSA? I would just stop there and say yes all the time. I don't think you need to go any further than that. They're always making mistakes. I mean, my wife and I have probably combined spent 60 years advocating for people with disabilities, and yet we're in a fight with Social Security every month because they continually make mistakes. They don't know their own rules. They'll tell you information that is completely incorrect. One of the things that has happened in the last year is it used to be if you paid for a person on SSI for their food, it would reduce their SSI check by a third. That's no longer true. They passed a law in 2024 that you can now pay for their food, no impact. So it used to be food, clothing, shelter. They've taken food and clothing off the table. The other issue is shelter. As long as the person pays their one third, this year, it would be like $350. If they paid $350 from their SSI check for their rent, then someone else can pay the balance of the rent and there's no impact on their SSI check. Okay. Two things that changed in 2020.
That's a big one, Kevin,
Yeah.
because a lot of people don't know that. And a lot of people have been telling me in classes and otherwise, well, they're taking $400 out of his check because he doesn't can't pay his fair share.
Yeah.
So,
That's no
yeah, that
longer true.
fair share thing, yeah, that's very
It's no
confusing.
longer true. You only have to pay what they call the in-kind support or presumed maximum value penalty, PMV, which is one third of the federal portion of the check, which and it's plus $20 because they love their $20 bill for some reason. But it's $352, I think, gets you right over the PMV. If they pay that amount out of their SSI check, it should not be reduced at all, except if you're paying their utilities too. If they have to pay their own utilities, okay?
So if they live in a house with three other people, their family, right? And so they would pay their one third of their check, and their utilities would be divided by the number of people in the house.
Um, that would be the simple way to do
Yeah.
it. Sometimes, we make it, we again, generally, yes, I would say generally that's true.
Yeah.
If
Okay.
it becomes a problem, we can advocate against that. It's just try to argue, well, they're not using that much utilities. There's a workaround though. If they qualify for ABLE and you want to pay for their utilities, but you don't want them to lose their one third check, put the money into the ABLE account and then let the ABLE pay for the utilities and there's no penalty.
Okay.
Call that legalized money laundering. It's completely legal. It's completely okay. So it's either the special needs trust or the parent, and you flow it through the ABLE account. And the same thing with rent too. But again, usually what we're doing is we're having the person pay like $352 a month off their SSI check. Either the special needs trust or the parent pays the balance of the rent, and then we flow the utilities through the ABLE account, and they're gold. They should get 100%. Now, is your local SSA eligibility worker going to understand this? Not always, rarely, but that's the rules. And so sometimes you have to advocate a little bit, but that
Okay, thank you. Yeah, that's important. Thank you so much.
can the letter of intent be added to an IPP? Sure. um, I'm not sure about that. I haven't really done a lot of IPPs. I don't know if they would have an issue with that. I don't see why they would though. I mean, again,
No,
it's mostly
it's
geared
a good
towards,
idea. Yeah, it's a
yeah.
good idea because anything in there can be added to the IPP, and in order for you to access the services and supports you want, it has to be in the IPP. So I can't, it wouldn't hurt.
Yeah, we do have to be concerned about Trump cutting funding to California benefits, although I'm a little surprised he has not cut some of them already. I mean, I know our asset test got reinstated. A lot of people thought that was Trump, but that was actually Newsom. He was trying to balance the budget and he brought that back. So I haven't seen them do anything particular to California thus far. I mean, I guess I shouldn't say that. The immigrants' eligibility for Medi-Cal has been cut, but that was, I think that's nationwide. That wasn't California specific. Can one who does not have capacity create a will? So you have to have what they call testamentary capacity, which is the lowest level of capacity to do anything. So they let you have the lowest level of capacity to create a will and get married. So I don't know what that says about society, but that is the way we have it here in California. But yes, you have to have at least, and basically testamentary capacity is you understand who the natural objects of your bounty are. That sounds like 18th century language, but that's um, basically you have to know who your heirs are. You have to understand all of them, and then you have to make an understanding of what your assets are, and then you have to understand that you're leaving your assets to these people. If you disinherit someone, you have to have basically an understanding of why you're doing that. But it doesn't have to be a firm understanding of like all the nuances and permutations. So it is not a huge level of capacity, but you do need capacity. You can do supported decisions. So conservatorship, and understand that guardianship is for people under age 18 in California. Conservatorship is for people over age 18 in California. So you do a conservatorship if they turn 18. A conservatorship in California, before you can get one, you have to be able to say, is this the least restrictive method for making decisions on this person's behalf? So you have to explain why supported decision making won't work. You have to explain why powers of attorney, advanced healthcare directives won't work. And after you do that, so if they do work, then yeah, that would be in lieu of a conservatorship. But generally, they're looking at the ability of the person to manage their own care. Would they be able to say no? Would they, undue influence is a big problem. Predators will target people with disabilities. Can they protect themselves from predators? And that's usually what we're looking for. A supported decision making agreement is great for many people. The one issue I have with them is I don't know about the teeth in it. I mean, if somebody ignores the supported decision making agreement, what are you going to do? Sue them for breach of contract? I haven't seen, because it's still a relatively new law in California, but it does allow for the person with disability to retain some control over their own person. Because again, we're taking away their civil rights with a conservatorship, which can be a big deal. Now, for many of my clients, that's the only option. I mean, they completely cannot protect themselves, so they need somebody there to do it. But for many of our clients, they're high functioning. They have really good capacity in some areas and much less in others. So that's what we call, sometimes you'll hear it referred to as a limited conservatorship, which means it's just you pick and choose the powers that they need assistance with, and they could retain the powers, like the power to vote, social sexual contacts, contracts, residence, medical decisions, and you pick the certain powers that they can control, And usually the regional center will make a report where they think the person has capacity to manage their own affairs in these areas. And I'll tell you, they've made a political decision that nobody should ever give up social, sexual, and marriage. I don't know why, because again, we had one young woman who was severely autistic, and when she was 18, they wouldn't give her social sexual power to her parents to continue that control. And a 52-year-old registered sex offender groomed her and got her to move in with him, which was awful. And she needed protection. But when they went to the police, because they didn't have that power, they had no authority to stop that from happening until they went back to court, obviously. But again, we don't want to avoid that. So just understand supported decision making is good, but again, there's not teeth in there yet that I'm aware of. And I'm sure that someday there will be when something bad happens. Usually the courts will get involved, and then we'll see what kind of teeth it has. But generally, I recommend if we can get a power of attorney advanced healthcare directive, if they have the capacity to sign those documents, they have to understand what they're signing, they have to understand who they're appointing. And then if they can't, then the conservatorship. So it's supported decision making first is the least restrictive of the least restrictive. Powers of attorney advanced healthcare directive, it's a little more protective because there's legal bite to them. And then the most recognized, the most legal is the conservatorship because you have a court stamping it. There's a seal on there, there's letters of conservatorship. You send it to the doctor, you send it to the financial institutions. They ignore it. It's a contempt of court. So again, that's the most protective. Can you use your daughter's ABLE account to pay for someone to set up her special needs trust? I think, I mean, I would say easily yes if they're setting up what we call a first party trust, because that's like, let's say somebody dies and leaves them $50,000 insurance and it goes right to their name. Well, we have to set that money up into what we call a first party special needs trust. That's obviously for their benefit. Third party, like let's say you want to use their money to pay your attorney to create a special needs trust for them, I think you could probably do that. Um, what you don't want is to pay for the parents' revocable living trust, which is their stuff. But that one part, the special needs trust, I'd make a good argument. I think that would be a qualified disability expense. What is better, an SNT or CalAble? Well, I mean, depends on your situation. If you've got $18,000 in cash that just got handed to you as a person with a disability, ABLE account is far superior because they can just spend 15 minutes, open an ABLE account, fund the money in, they're good. If you got 500,000, you're going to have to use a special needs trust. So ABLE accounts are good if you have small amounts of money. They're also okay if you have somebody who can manage the ABLE account. Special needs trusts are really more for long term, and they're for bigger assets. So usually when you're receiving an inheritance from a parent's estate, they're getting a decent amount of money. You'd want a special needs trust. ABLE accounts are just a tool. They're both basically the same. They're exempt. They don't interfere with SSI. They don't interfere with Medi-Cal. But special needs trust, you really need them for bigger assets. Where are we? Can a trust hold a residential property and rent the property under Section 8? You can. Well, when you say trust, generally a parent can't rent to their children under Section 8. But so if it's a revocable living trust of the parents, probably not. But for a special needs trust, it's say third party, it's its own entity. You can. It takes some advocacy. A lot of local public housing authorities, some will grant it, some won't. So you have to really work to get that. But it is a nice way to bring some revenue into that special needs trust because the government's paying, everything in rent above the 30%. So, uh, yeah, some people are talking about Prop 19, and so generally it used to be a parent to child transfer was exempt from reassessment. Prop 19 did away with that. Generally, now they're still a limit is, as long as the child's going to continue to live in the property and they lived in there before, then they can get like $1 million increase exemption. But California, sometimes that can be a lot higher than that. There are attorneys out there that are pitching ways that they can get around that. I'm not one of those attorneys. I go more conservative on these things, and so if you're looking to do that, there are attorneys out there who advertise that. I'm not 100% sure that stuff's going to work. Usually, they're using some type of LLC arrangement, or something creative where they're doing some kind of lifetime transfers and getting things over. It's just not something that I'm comfortable doing. But there are attorneys who do pitch that, and I don't know if it's going to work or not. Um, what vehicles can we use to protect monies aside from CalAble? Well, special needs trust would be the primary one. Special needs trust, CalAble, those are the only two kind of financial accounts you can put money in. Um, for both of those public benefit programs, a primary residence is exempt, one vehicle is exempt. Um, you can get a life insurance policy with a cash value of no more than $1,500. That's exempt. Personal belongings are exempt. So you can get like assets, some of them, but if you have a second vehicle, that's counted, so you have to be careful. Jewelry is exempt unless you're using it for investment purposes. Again, there's all these weird exceptions. But financially, really, the ABLE account and special needs trust are really the only ways you can have like investment assets and not have them count. Now, retirement plans are a little different. Um, Generally, if the person owns a retirement account under SSI rules, generally they're countable. But if they're a Medi-Cal only person, they don't qualify for SSI, just Medi-Cals. If you put it into what they call payout status, where it pays out a little bit of money, they won't count the asset. They'll just count whatever you distribute out as income. So there's a way to avoid having to liquidate that retirement account if the person is qualified for just Medi-Cal. Um,
Let's take two more questions and then,
okay,
yeah.
let's see. Let me see if there's a good one that's going to be really. They're all good. I'm sorry.
There's no wrong question, right?
Uh, let's see. Yeah, so one of the big confusions out there are the types of special needs trusts. So understand that the government, for SSI and Medi-Cal, these are kind of welfare programs. These are for programs for people who don't have money. And so they figure, the government says if people have money, then they shouldn't be getting these programs. Now, they've created an exception for people with disabilities. As long as you meet the definition of disability for these programs, you're allowed to put your money into a trust. But the government makes a distinction. They're like, if the person themselves has money and they put it into a trust and say, hey, look, I'm poor, give me these benefits, they don't like that. They don't like seeing that. They feel like you're gaming the system. But they've created this small, what we call safe harbor, which is a first party special needs trust. And they make the rules though kind of challenging for that first party trust. It can only be established by a parent, grandparent, legal guardian, the court, or the person with the disability. It has to be used for their sole benefit, meaning only they can benefit from that trust. And on their death, if there's any money left in that, it has to be used to pay back Medi-Cal. It's called the payback provision. So you have requirements. They're like, hey, we're giving you this benefit, right? To let you put money in a trust, use it to enhance your quality of life. I'll let you keep these valuable benefits that we're paying for, but on your death, you have to pay back Medi-Cal. That is first party. That is when a person themselves has money. But the government loves it when other people pay to help that person out. They call that third party. So if mom and dad want to leave an inheritance, grandparents, any third party wants to benefit that person, as long as you direct your money directly into a third party SNT, it can serve the same function. It preserves benefits. They can use it to enhance their quality of life. The big distinction is on their death, that money stays with the family. It doesn't have to go to pay back Medi-Cal. So really the distinction is whose money is being put into the trust. Is it the person with a disability? Then you have to use a first party special needs trust. Anyone else, third party. But remember, it has to be directed into a third party trust. So I get questions a lot. Well, I received an inheritance. It's in my name, but I want it to go into a third party trust. It's too late. You can't do it. Once the money's legally yours, you can't shift it into a first party. A revocable living trust is just mom and dad. They're putting their assets in and they're directing what they want done with their assets in the event they lose capacity or after their death. It's like a probate avoidance type of entity. And so a revocable living trust is, it's much like a will. So in a will, you're saying, I want X, Y, Z to get this asset after my death, but that will has to go through probate, which is a court process. You have to pay money. There's all kinds of expense. Revocable living trust does the same thing, but you avoid court. And so it's much more flexible. So in California, almost everybody has revocable living trust who does planning. And then the revocable living trust would say, on my death, my loved one with special needs gets their money in a third party trust. Okay, third party special needs trust. Okay.
Kevin, you have outdone yourself. I think we're just going to wrap it up there. I really appreciate you spending the extra time to try to answer everyone's questions. And everyone on the call today, thank you so much for your time and for your interest. We will be sending out more information in our thank you letter, all of the resources that Kevin has shared with you today. And I want to remind everyone that we do have future planning classes with the ARC of California's Caring Future program and self-care matter classes, and you can access and register for those at caringfutures.org. And also that will and connect on our mailing list for updates and offerings. And also our Facebook group is another great way to stay connected with us. Thank you all so much for your time today. And Kevin, thank you again for joining us. Really
Thank you.
appreciate it.
I love it. Anytime. Let me know. Thanks.
Thank you so much. Have a good day, everyone. See you next
Bye.
time.